You know that feeling? You're trying to enjoy an afternoon in your own garden, but all you can smell is that sharp, chemical stink of paint coming from a nearby garage. It's way more than just annoying, it could actually be illegal. So in this explainer, we're going to break down what your rights are and the exact steps you can take to clear the air.
Right. So what can you actually do about it? It's so easy to feel like you're completely powerless against a smell that just won't quit, but you're not. The law is really on your side here, designed to protect your quality of life, and it gives you a pretty clear path to get it sorted. Let's dive in.
Okay, first things first. We need to understand when a smell crosses that line, from being just a pain to being an actual illegal nuisance. And this is where the law gives you a really specific and powerful tool.
This is the key phrase you need to remember: statutory nuisance. It's a powerful idea from the Environmental Protection Act of 1990. A smell becomes a statutory nuisance when it is one of two things. It's either prejudicial to health or, and this is often the real kicker, it unreasonably interferes with you just enjoying your own home.
Now, the law has a reasonable person standard, and this quote, from a court case all the way back in 1872, kind of sums it up. It means the law doesn't really protect someone with, say, a super sensitive nose. The real question is, would the smell bother the average person? It has to be a genuine problem, not just something tiny that you happen to notice.
So, an environmental health officer, they're going to use one of two legal tests. The first one, prejudicial to health. Well, that's a pretty high bar. It asks if the smell is literally likely to injure you. But the second one, nuisance, is usually much more straightforward. Does it stop you from opening your windows? Can you not sit in your garden? If the answer's yes, then you've got a nuisance.
And the law is also pretty specific. It sees fumes or gases from a private home, like maybe a hobbyist in their garage, differently from dust, smell, or other efflua coming from a professional business. And a commercial paint sprayer? Well, it falls right into that second category.
Okay, so you're thinking, yep, this is a statutory nuisance. Who do you turn to? Well, your local council's environmental health officers are basically your first line of defense.
And this part is absolutely critical. Your local council has a legal duty to investigate. They can't just brush you off or ignore your complaint. If you live in their area, they are legally required to look into it.
You might be surprised how they investigate. It's actually pretty hands-on, or maybe noses-on. They use trained officers, human sniffers, to assess the smell's strength, how often it happens, and what it's like. But look, they can't be there 24/7, right? That's why your smell diary is probably the single most important piece of evidence you can give them. So while the council's looking into it, what about the business itself? What are its responsibilities, and do they have any kind of legal defense? The main legal defense a business can use is something called Best Practicable Means, or BPM. But let's be clear, this is not a get-out-of-jail-free card. It means the business has to prove they are doing everything reasonably possible to fix the problem, using the best tech they can while also thinking about costs and local conditions.
So what does Best Practicable Means actually look like for, say, an automotive paint sprayer? It's not some vague idea. It means using very specific, practical controls.
This is what a responsible garage should be doing. All spraying has to happen inside a totally enclosed booth. They need effective filters, high-efficiency spray guns, a proper system for cleaning their gear, and their exhaust vents need to be designed to spread the fumes out properly. This is the standard they have to meet. And for the bigger businesses, the rules get even tighter. Any place that uses more than a ton of solvent in a year needs an environmental permit. And that comes with really strict conditions, including basically a zero-tolerance rule for any offensive smells leaving their property.
So what happens when a business just isn't meeting these standards and the council agrees with you that there's a real nuisance? Well, that's when the enforcement process kicks in.
Once a statutory nuisance is confirmed, the council doesn't have a choice. They are legally required, they must, serve what's called an abatement notice. This is a mandatory step. So what is it? An abatement notice is a formal legal order. It tells the business they have to stop or limit the nuisance. It can even spell out the exact work they need to do and give them a deadline to get it done. And ignoring that legal order? That comes with a very, very steep price. If a business doesn't comply, it goes to court, and the maximum fine is huge, up to £40,000. And let's be absolutely crystal clear on this. Failing to comply with an abatement notice isn't like getting a parking ticket. It is a criminal offense. Okay, we've covered the law, the investigation process, and the serious consequences. So now let's put all of that together into a simple, clear action plan just for you.
It really just comes down to 3 easy but effective steps. First, start that smell diary and write everything down. Second, get in touch with your local council's environmental health department. And third, give them your evidence. A really clear diary makes your case so much stronger and empowers you to take back your right to a peaceful home.
So, is the air on your street protected? You bet it is. This explainer has given you the tools to understand your rights. The law is there to protect you, and now you know exactly what to do to make sure that protection is enforced.